Kasi po, kagaya po nung sinabi ni ASEC Jermar kanina, ang DOJ ay talaga namang siya yung ating principal law agency sang-ayon sa ating Administrative Code of 1987. Di ba ma'am, sinabi mo kanina? Sa napaka-importante po ng role na ginagampanan po ng DOJ. Earlier po in our work in the Senate, more particularly the Blue Ribbon Committee, this representation as the erstwhile chairman of the Blue Ribbon Committee tried his best to get to the bottom of the investigation. We're talking about the flood control anomalous projects. Ang sabi pa nga namin noon, sisisirin po namin yung baha na yan para makita natin ang mastermind. Napakahirap po ng objective na sinet ang inyong lingkod kasi ayoko naman ng na-pinpoint lang natin. Sabi ko nga, puro sap-sap lang o maliliit na isda. Dapat yung matarget natin, yung pinakamalaking isda. Kasi siya yung nanggulo ng sistema kung bakit nangyari sa atin ito. And so, I maximize the potential. Naisip po yung Witness Protection Program. Dahil sa hirap po ng pagpipinpoint ng utak talaga niyan, mangangailangan ka. So I floated the idea doon sa 15 contractors initially invited in the hearing. Ang sabi ko sa kanila, well, ano po ito, napakahirap po ng inyong kinasasadlakan ngayon sa investigasyon ito. Unang-una, yung offense po na ating pinag-uusapan is a major offense. Plunder nga po ang mangyayari rito. At least marami pang iba. So, kung gusto po ninyo na tulungan ng Estado, meron po tayong remedyo rito because this is legislative investigation. And under the Witness Protection Program, Section 4, sinasabi niya, kung gusto po ninyong tulungan ng Estado, mahirap po ang gagawin nyo, ngunit may nakalaan pong protection and benefit provided by law. So, nung pinload ko po yung idea na yon, dalawa po yung lumabas, yung mag-asawang Diskaya. And initially, enumerated 17 members of Congress, House of Representatives. Ang nangyari po, kasi hiningi naman nila yung Witness Protection Program, so nung panahon ko po, I recommended that they be processed under the Witness Protection Program. So sumulat po ako sa Senate President, yun naman po yung dapat kamalasan naman po, yung araw din na yun, nagkaroon ng coup. So napalitan po ang Senate President, yung naging Senate President, ayaw niya na po. Ayaw niyang ituloy. At dahil nga po, merong sinabi yung former Secretary of Justice, we cannot process them until and unless they return yung kanilang mga ninakaw, blah, blah, blah. So the new Senate President, pinangatawanan niya yun. Oo nga naman, sabi niya, the Secretary of Justice, sabi niya, that's a good policy. Kailangan mag-restitute muna sila before they can covered by the WPP. Paano po? How can we begin to even pretend that we know what to do and to help the state prosecute? Kung sasabihin na kahit nawala po sa batas, ipipilit halimbawa ng inyong dating secretary na kailangan mag-restitute muna. I told him it is not a requirement under the law. But he insisted in saying, well, yeah, it's not in the law, but we can always agree on something like a good policy for the state. Do you agree with him?
I agree with position of Secretary Boying Rimulya, now the Ombudsman. Basically, it being one of the conditions. When we look at this, Your Honor, no, we're looking at on the ultimate objective. Paano yung Estado mananalo at mapapanagot itong mga to. Wala pa pong tapos sa pagpoproseso ng mga nakasalang na nag-a-apply po ng Witness Protection Program. Kasi kaakibat po sa pag-aaral na to, kasama rin po yung under the Witness Protection Program, kasama rin po sa pag-aaral ng atin pong prosecution team na yung paano kung pwede ba under Rule 119 naman pagpasok po. Marami pong iba't ibang binabalangkas at pinag-aaralan, Your Honor. At itong mga bagay na to, pwede pa pong makapagdagdag. Ipapasa ko ho kay Chief Dong at ito po ay aming masusing pinag-aralan at ilalahad niyo po yung iba pa pong mga prosesong tinitimbang. Wala pa pong sarado, Senator. Lahat po ay tinitimbang pa. If with the permission of the Senator,
Hindi, ang ibig kong sabihin,
Opo.
kung ipipilit na merong restitution kahit wala sa batas, so how can you process the application, for example, of the applicant? Kasi, kapag tinignan mo yung, I think the applicable section is section 10. Basahin mo yun, wala namang restitution. So, kung ipipilit natin that somebody should first restitute, doon pa lamang sa title ng batas, Secretary, it is all for the benefit, interest, and protection of the witness. To burden him or her with additional requirement which is not in the law. Hindi ko ba intindihan? How can you agree with that?
Your Honor, ang tinitingnan po dito ay yung pangkalahatan.
No, I'm talking about
Opo.
the WPP.
Opo.
What pangkalahatan ang sinasabi ninyo?
Ang kailangan po kasi sa dulo nito, manalo po yung Estado laban po.
Kaya nga, but before you do that,
Opo.
you have to proceed with the process.
Yes, opo.
So, paano siya mapoprocess? Kung ipipilit po na mag-restitute muna, for example, ano i-restitute niya? How much? Sino magkukompute? How can it be done? Sino ang magsasabi na ganito ang dapat niyang i-restitute? Meron na bang ano? Meron na bang pronouncement? We are in the process of asking their help to identify yung mastermind. It cannot be done easily. Kaya nga natin ginamit ang batas na to help the state. Ngayon, kung kayo po pala ay mag-prescribe ng isa pang requirement which is not in the law, I cannot believe this. Ito yung dilemma namin eh. Kaya nung pinipilit niya, sabi, and ako po nagtataka kung bakit kayo rin nag-agree kayo. So ano po talaga, kayo po yung ano eh. Ang DOJ is the principal law agency. If the principal law agency of this government will not even understand the basic requirements of the law, para lamang magkaroon ng nag-a-apply pa lang yung tao po eh. Imagine, hindi man natin masasabi kung ultimately magko-qualify siya eh. Or even if he qualifies as a state witness, kung hindi niya naman nagagampanan ang tungkulin niya under the program, pwede mo rin siyang alisin eh. So, the point, Mr. Chair, is they cannot even begin to be processed under the law kasi naglalagay po kayo ng requirement which has not been included by law. Sino yung mag-explain ulit? Sabi? May I be educated on that?
Yes, Mr. Chairman. I just wanted to make an attempt to reconcile the debate on this matter. There's actually no inconsistency. First, it is correct that under Section 10, the law provides for the qualifications for a person to be qualified as a state witness. Nandun po yung materiality at absolute necessity ng testimony ng tao at corroborated po to on its material points by other witnesses. and that he is not the most guilty. Okay. Now, under Section 5, which refers to the memorandum of agreement that has to be executed between the DOJ and the potential state witness, nakalagay din po dyan yung necessary matters that should bind the agreement dito po sa Witness Protection Program. And under Section 5, letter D, nakalagay din po dyan kung ano po yung legal obligations and civil judgments or civil aspect of the case against him. Ang ibig lang pong sabihin niyan, kakausapin naman po siya, maari pong i-process yung application niya, but under the first statement under Section 5,
What is specific provision under that law,
Section-
under that provision?
Section 5 po says
Ano nga,
that
basahin mo.
before a person is provided protection under this act, he shall first execute a memorandum of agreement
Okay?
which shall set forth his responsibilities, including the following.
Oh, ano
So
nga?
kasama po dun sa
Ano
mga
nga?
obligations.
Ano nga?
Ito po, to comply with legal obligations and civil judgments. So doon sa civil judgments po, this refers po to the civil obligation pertaining to the
May
crime.
civil judgment.
No. We are saying legal obligations. Ang basis po ng legal obligations
The basis of legal obligation is the law itself.
is the law itself,
Oh,
which
walang
includes,
nakalagay na restitution. Bakit mo ikokot yung
which includes
memorandum?
po other provisions of law, including the civil code on unjust enrichment. Kasama po yan. Every law should be read consistent and harmoniously
Paano mo nga
with other
i-apply
provisions of
yun,
the
even
law.
the civil code? How can you apply? Paano, ano yung i-restitute niya? Alam mo, magkakatalo lang tayo rito eh.
Hindi ho.
The DOJ
let me
is in a position to even calculate how much the applicant should restitute before he can be processed under the application.
I'm making a distinction po between process and enjoying the benefits under this act. So, ipoprocess na po yan dahil matagal po naman ang paraan para malaman at matuntun ang lahat ng civil
wala
obligation.
pa nga pong statement whether or not meron nga sila. Wala pa tayo eh.
Kailangan po natin makuha ang mga statement ng mga potential witnesses. Kailangan pong evaluate, kailangan pong malaman
Doon sa,
kung ano po
doon
yung
sa memorandum
lahat po
na
ng
sinasabi mo, Yusek, sinasabi restitution?
Opo, kasama po.
Sinasabi dyan?
Hindi, ang word po dito ay civil and legal obligations. Understood po na ang legal obligations has many sources.
Saan ang
Kasama
gagaling
po-
ang obligation? The law does not provide restitution in the first place. That is very simple.
Legal obligation po has a
Huwag
specific
kayong
definition.
mag-imagine ng argument, Yusek. Magtatagal lang tayo rito. This is very simple enough.
Apo. Anyway, ang sinasabi ko lang
Kapag
po,
ka ba hindi provided ng batas, magiging reasonabling obligation under the provision you're quoting?
we are saying that legal obligations is defined under
You
the law.
cannot
And legal
even
obligations
you
includes
cannot
unjust
use
enrichment.
your opinion will even matter here. That's your opinion. Ang pinag-uusapan natin is the requisite of law. That's the maxim expressio unius est exclusio alterius ring a bell to you.
Alam po natin yun. Ang
O anong
sinasabi
ibig
ko po,
sabihin nun?
ang what is expressed excluded is not included.
Kaya nga.
So-
You are including an opinion which was not expressly enumerated under Section 10 of the law.
Hindi. We submit, Your Honor, that a witness can be processed under this program, but he cannot receive any of the benefits as stated in Section 5 unless the matter referring to legal obligations is reduced into writing in a memorandum.
So,
Yan
Mr.
po ang
Chair,
position namin.
the opinion of the USEC is trying to supplant the very clear and categorical provision of law.
We submit, Your Honor, we're just reading the text of Section 5. Your Honor, may I also add, we are trying to get to the bottom of the investigation.
You are adding an opinion and you are supplanting the basic provision of law. You cannot do that. And sabi pa nga natin, the spring cannot rise higher than its source. Tama? Paano? Pati opinion mo, gagamitin natin. Sana wag ganun para hindi na tayo magtagal. Ano? Paano nyo mapoprocess ngayon ito, SEC, Vida? Kung ipipilit nyo halimbawa, tingnan nyo hanggang ngayon, what is the status of the application, for example, of the Discayas? I am not defending them.
Opo.
Kaya ko lang po pinipilit ito because kagaya ng sinabi ko, gusto nating ma-identify yung mastermind.
Opo.
Kung ayaw ninyong i-identify yung mastermind, that's a different matter altogether. So, kahit na wag nyo na siyang i-process, okay lang. Pero kung gusto nyo malilit na isda lang, kaya ayaw niyang i-process, nasa sa inyo yon. Nasa sa inyo yun. Kasi dito sa inyong presentation, yung Office ng Secretary, yung law enforcement program ninyo, yung percentage of successful prosecution, meaning conviction vis-a-vis acquittal, is 90.14%. Pero yung percentage of successful prosecution in cases with witnesses covered by the program, it's 95.3%. And then the third, percentage of successful prosecution in relevant cases handled by the DOJ prosecutors, 80.5%. So dito mas mataas talaga yung success if you will use the WPP. Hindi nga ako, nagtataka nga ako kung bakit averse kayo dun sa pag-process dun sa... Samantalang wala namang nilalagay na restitution, ipipilit nyo para lang hindi sila makover ng program. So ano mangyayari sa batas natin? You will insist on an opinion supplanting the requisites categorically provided by law. Ay hindi talaga makakapaprocess. So pinipili nyo yung gusto nyo i-process. Paano natin, sila lamang ang nakapag-identify initially ng 17 congressmen. At doon sa kanilang mga testimony, lumalabas na rin ang pangalan ni Saldico and Martin Romualdez. Ngayon, kung ayaw ninyong bigyan sila ng protection under that law, kaya siguro umayaw na sila sa ICI. So what is their status now with the DOJ? Are you insisting that they restitute? How much? How do you compute it?
If I may, Your Honor.
Oh, yes.
If I may, Your Honor. To be consistent, the Department of Justice...
No, you are not consistent from the beginning. Huwag mo sasabihin to be consistent.
Okay.
There is no consistency here.
Sige po.
Magkano ang gusto nyong restitute nila in the first place?
Okay. Wala pa po sa estado na ganon.
So mga tweet, hindi mapoprocess talaga yan.
Pinoproseso po namin, Your Honor, yung kanyang application.
How can you process the application, Mr. Chair, if you are providing another requisite which is not even written in the law? You are imagining something that is not within the law. You are Department of Justice. Ito yung sinasabi ko sa inyo. You're supposed to be the chief.
Pwede ho bang magdagdag, Your Honor? Halimbawa po, sa pagitan po ng pagpapalitan ng statement mula sa witness, sinabi ng isang witness, 'di ba? Kasama ako sa sindikatong ito. 'Di ba? At dahil sa kumita ako dito sa pagsali ko sa sindikatong ito, kumita ako ng 10 milyon. Kuwasa ho ba naman hindi pa kukuhanin ng DOJ bago siya matanggap sa Witness Protection Program? Mga practical na aspeto lang po, Your Honor.
So ano nga sinabi sa inyo ng mga diskaya? Na-determine ninyo kung magkano ang kinita nila?
Kaya po, Your Honor,
Nakuha nyo na ba? Did they admit to you na sila ay nangulimbat ng ganito karaming pera? I have to explain myself.
yeah po.
Hindi ko dinidepensa ng mga tao ngayon.
Opo.
Ginawa ko lamang yon doon sa nalalaman ko na ma-identify natin ang pinaka-mastermind dito. Yun lang, wala nang iba.
Opo.
Kung gusto nyong ang ma-identify, puro butete at saka sapsap, bahala na kayo sa buhay nyo.
Gusto rin po namin, Your Honor.
Gusto nyo pala eh.
Opo.
Why are you putting a requirement that is not within the law? Tsaka na natin sila pag na-prosecute na natin yung mandarambong, na-prosecute na natin yung mastermind. Bakit? Makakalampas ba sila sa civil liability? Of course, the court will in proper time, adjudicate kung anong dapat nilang isoli sa gobyerno. That is the only time when restitution can be done. Kasi mayroong court order eh. Pero sa ngayon, will you abuse your discretion na kaya niyong gawin ito kahit na wala sa batas? How can the Department of Justice do that? You're supposed to be the embodiment of justice. Mr.
Thank you, Senator Marcoleta, and would like to implore on the Department of Justice to reflect on the exchange between
Ang ICI ng ilang piskal na para tulungan sila. Dahil ang may kakayanan po na magbalangkas ng mga ebidensya na naiipon at impormasyon ay ang mga na atin pong mga kasalukuyang mga taga-usig. So ito po yung magkabilang tulungan po na amin pong binibigay para sa ICI.
Sir,
yeah, yes, go ahead, Senator.
akala ko ba ang ICI is an independent body? Pagka independent, gagawin niya sa sarili niya, di ba? Tama.
Opo, ang ano po is yung
Teka
pagtulong.
muna,
Apo.
sumagot ka lang.
Opo, Senator.
Independent, di ba?
Opo.
Ba't kinakailangan siyang humingi ng tulong sa mga fiscal ninyo, prosecutors? That is not being independent. Tama?
We submit to your wisdom, Your Honor.
Of course. Kasi nga, tingnan mo yung creation niya. It should be sa pangalan pa lang, independent, ano na yun, Che? ICI. Independent Commission on Infrastructure. Pag binasa mo yung kanyang mga powers, di ba? This is something that also the senators will, one way or the other, discuss probably in the course of time. Sabi niya, upon request, it can obtain information from the House of Representatives, the Senate, the courts, the Ombudsman, and other authorities. So paano yun? Bakit ka independent? And dami mo namang nagre-request ka kung kani-kanino eh. Can the Senate refuse, for example? In observance of the separation of powers. Halimbawa, nag-request siya, address to the Senate President. Wala pa kaming choice. Because there are institutional boundaries. We need to exercise the system of checks and balances. So sasabihin niya, Independent Commission on Infrastructure. Paano kang independent and dami mong kinakasangkapan, hingi ka ng hingi? You should obtain the information by yourself, all alone. Yun ang independent. Tama?
Yes, Your Honor.
Okay. May I continue, Mr. Chair?
Oh yes, go ahead, Senator Mark.
You're familiar with the now famous statement, sometimes you have to bend the law to please our people. You're familiar with that?
Not so familiar with that, Your Honor.
How come you're not familiar with that? May I refresh your memory?
Yes, thank you, Your Honor.
We were talking about, this issue of restitution and blah, blah, blah. Hanggang dumating yung isang point where one of us made a suggestion. Sometimes we have to bend the law in order to please the people. And he asked the former Secretary of Justice for affirmation. Am I correct, Mr. Secretary? And the Secretary said, yes, sir. You agree with the affirmation of the Secretary of Justice?
I do not agree.
Thank you.
I do not agree because basically in implementing the law, there are positions you can take, but bending the law is not one of them, Your Honor.
Buti na lang ganyan na sinagot mo. Kasi sa ibang mga interview, sinasabi niya, oh, bending the law is okay, basta wag lang breaking the law. How can you accept that kind of statement? You cannot bend the law. No one is above the law, sabi pa nga natin. And the overarching principle in the promulgation of our Constitution is upholding the rule of law. No one should bend the law. Not even in imagination. Mahirap po yun eh. Kasi kung sinabi mong you agree, ang dami po kasi nagte-text sa akin, Yusek Andres. Ganyan palang ginagawa sa mga taxes na binabayad namin. Mga buwis namin. Hirap na hirap kami. Mga halos dugo, pawis. Minsan may kahalo pang sipon. Makapagbayad lang kami ng tamang buwis sa ating pamahalaan bilang mga patriotic na citizens. Pwede mo ba, sir? Sabi nila sa akin. Ilaban mo naman kami. Yung 2026, wag na muna kami magbayad ng tax. Because somebody said, sometimes we can bend the law to please the people. I may be able to please them, Secretary. Kasi yun ang text nila. Can I say yes to that? Can I?
You
Thank you. Ito pong Secretary, yung pagkaka-transport ng dating Pangulo ng Republika sa The Hague. Ang pagkakaalam ko po kasi, maraming pronouncement ang ating Pangulo. Yung iba na-memorize ko pa nga po eh. We will not assist the ICC in any way, in any form. From now on, I ask my secretaries to do the same. I mean, something like that. Pero nangyari, kabaligtaran, Secretary, di ba? The former Secretary of Justice explained that, well, those pronouncements are not cast in stone. Ito na naman eh. Ito yung parang ephemeral lang nangyayari. Parang the government officials' decision, sabi niya, sometimes can be changed at times. What do you think are the factors that necessitated a change of mind? Like from not assisting the ICC in any manner, in any way, in any form, he was just transported there. Now languishing in the detention center on the other side of the planet. What do you think are the factors used by the DOJ?
First, Your Honor, if I'm not familiar to the particular circumstances that the secretary, the particular facts that which made the secretary made the actions
Who is
before.
familiar? Who is familiar from
And
among
second,
you?
Your Honor, if I also may state, the matter is pending now with the matter before the Supreme Court. So the position, the legal position on the actions of the former Secretary of Justice has been elucidated with the court. But for the Department of Justice, it's Chief Dennis Chan who made the argument and presented the position of the DOJ in this regard, Your Honor.
My question is, what are the factors that necessitated a change of mind from not helping the ICC in any way, in any form, which is a policy matter, with the reverse? That happened.
I'm not privy to that, Your Honor.
Who is privy? Kasi parang
Your Honor, it may be the former secretary, now the ombudsman.
Oh, wala na siya
Overview.
sa DOJ. Nasa ombudsman na siya. Alam nga namang
Yes.
ipatawag natin siya rito.
Eh,
What happens now to the principle of continuity? Well, people might say and suspect that, even policy matters can be changed by mere whims or caprices, which are not probably based on sound legal basis. You are familiar with Republic Act 9851. This is our Philippine Act on crimes against international humanitarian law, genocide, and other crimes against humanity.
not so familiar with that. 9851, Your Honor.
Kasi, Secretary, under that law, ang jurisdiction po ng mga tao na nagkasala under this law, under Section 17 of that law, the state shall exercise jurisdiction over persons, whether military or civilian, suspected or accused of a crime defined and penalized under the Act, regardless of where the crime is committed, provided any of the following conditions is met. The accused is a Filipino citizen. The accused, regardless of citizenship or residence, is present in the Philippines, or the accused has committed the said crime against a Filipino citizen. So if these are the assumptions in the law, ang Pilipinas ay may jurisdiction. And under Section 18, the Philippine courts, prosecution, and investigators, the regional trial courts of the Philippines, shall have original and exclusive jurisdiction over the crimes punishable under this Act. Ngayon po, if we consider the applicability of this law, bakit po na-transport yung dating Pangulo natin at hindi natin nilitis sa sarili po nating jurisdiction?
If with permission of the Honorable, may I refer to the Chief Dennis Chan?
Good morning, Your Honors. Good morning, Senator Marcoleta and Senator Gatchalian. You are correct, Your Honor, that Section 17 on jurisdiction provides for the state exercising jurisdiction over persons suspected or accused of committing a crime penalized under RA 9851. The second paragraph of Section 17, Your Honors, thus mention that in the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crime. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state pursuant to the applicable extradition laws and treaties. Your Honor, I believe this was the justification relied upon by the former Secretary of Justice in the action leading to the transfer of the former President, Your Honor.
So, Mr. Chair, they are referring to the second paragraph of Section 17 of 9851. Is that correct?
Yes, yes, Your Honor.
Mr. Prosecutor, I noted that, but I think the colatilia is very, very clear. Pursuant to the applicable extradition laws and treaties. This is absent. So how can you invoke this? Wala na tayong treaty. We have just withdrawn from the Rome Statute. So this cannot be applied. Is that correct?
Your Honor, the way we interpreted that second sentence of Instead, the authorities may surrender or extradite. We see there two different actions to be taken by the state. It's either to surrender or to extradite, and then if it is to extradite, then it must be pursuant to an applicable extradition law or treaty. So the action taken, Your Honor, was surrender and not extradition.
Pero ang sinasabi niya, pareho sila eh. Yung dalawang conditions na yun will be cut under this pursuant to the applicable extradition laws and treaties. Wala tayong extradition law, wala na tayong treaty because we just withdrawn from the Rome Statute. Hindi mo pwedeng gamitin ito. Kaya dapat yung mag-a-apply is 9851. This is our own law. Okay lang naman dito eh. Can we not prosecute the former president kung talagang meron siyang kasalanan? Our National Prosecution Service, the judiciary, I think, is or are operating and they're willing, they're competent enough to prosecute, adjudicate, and proceed with the trial. Hindi ba?
Your Honor, with all apologies, I am not able to answer the question as to whether we can prosecute. I am just merely stating that the action of the former Secretary of Justice in for the transfer of the former president to the ICC was premised on Section 17, RA 9851, under the second paragraph.
Yes, but what I'm saying is you cannot use this one because of the absence of an extradition law and treaty. That is the point here.
And Your Honor, that is the subject matter or among one of the issues that we raised or that is being discussed in the Supreme Court petitions that were filed.
Pero nangyari na kasi, dinala nyo na siya doon eh. Under the false claim na pwede nyo gawin because of this. But you did not complete the whole statement. Kung kinonsider nyo yung pursuant to the applicable extradition laws and treaties, hindi dapat nangyari yun eh. So ngayon, kung halimbawa, nag-argue kayo sa Supreme Court, nangyari na yun. Ando na yung mama, di ba?
Your Honor, if I may also explain, I have no knowledge or participation whatsoever in the events that
Hindi, okay naman yun. Kaya tinuro ka kasi ni...
Yes, Your Honor, to explain the legal justification or premise on
Yeah,
which
but the legal justification is wrong.
we submit, Your Honor, although that is already pending before the Supreme Court, Your Honor.
Thank you.
You're welcome, Your Honor.
Chair, salamat po.
Thank you, Senator Marcoleta, for those